Bonjour à toutes et à tous. Désolé du petit retard, du petit délai. J'enseigne jusqu'à 11h20 et puis on m'a mis à l'autre bout du campus, donc j'ai un peu de difficulté à arriver à 11h30. Donc voilà, désolé pour le retard. Merci de votre patience. Alors, je m'appelle Pierre-Luc Désiel, je suis professeur à la faculté de droit de l'Université Laval et je suis titulaire de la chaire de recherche du Canada sur la protection et la valorisation des données de santé. Et avec la chaire, justement, on s'intéresse à la manière dont on peut protéger la vie privée dans le domaine de la santé, comment est-ce qu'on peut valoriser les données de santé, et on essaie de s'inspirer pour s'intéresser à des problèmes à résoudre au Québec, de l'expérience plus internationale. Donc, on a développé, avec Marie-Pierre Jolicoeur, que je salue, doctorante à la faculté de droit de l'Université Laval, comme je disais tout à l'heure, j'enseignais ce matin, on a monté ce séminaire ou ce cycle de conférences où on s'intéresse à différentes expériences internationales en matière de protection, de valorisation des données de santé au niveau international. On essaie d'apprendre à travers tout ça des bonnes pratiques, des bonnes manières de faire les choses pour ramener cette expertise-là, cette expérience-là au Québec. Donc, c'est un cycle de conférences où on a 4 intervenants et intervenantes. Le premier, on est allé en Belgique il y a environ une semaine avec, j'oublie son... Avec Lucas Fontaine, pardon. Et aujourd'hui, on va en Afrique du Sud avec Salona Lutchman, donc que je salue aussi en français, mais que je saluerai plus tard en anglais. Donc, je vais faire la transition vers l'anglais. Donc, hi everyone, thank you for being here. My name is Pierre-Luc Désiel, and I'm a professor of law at Laval University. And welcome to this second installment of this series of conferences on health privacy in research context. And so today we are very happy, very fortunate to have with us Professor Salona Lutchman. Salona is a senior lecturer in the Department of Public Law at the University of Cape Town. She is also currently responsible for the postgraduate program on human rights, and she also teaches the elective course International Human Rights in the Constitution as part of the LLB program. She's here today to talk about defensive medicine and protection of children's rights in South Africa. So, Salona, thank you very much for being with us tonight for you, today for us. So, thank you very much for being here. We are very happy to hear from you. The floor is yours. You have 45 minutes up to an hour. It's up to you. And afterwards, we can have a discussion. We'll have some questions. We have a small but engaged group today. So, again, thank you very much for being here. And the floor is all yours.
Thank you for the introduction. I hope you can hear me.
Yes.
Okay, great. So thank you to Marie-Pierre and thank you to Prof. Pierre-Luc for organizing this seminar. It's a great pleasure for me to be invited and to be part of this seminar series. Unfortunately, my French is very limited, and so I apologize that this talk is completely in English. I'm really looking forward to your questions. I think you've just come out of lectures, and so you probably are eager to, I'm very impressed that it's lunchtime and you're all still eager to listen to another talk. So thank you, those of you who are in the room and online. Thank you for joining. So today I am going to talk about something called defensive medicine and the rights of the child. I'm just going to share my screen, and maybe Marie-Pierre, you can just let me know if it's clear.
It's working, yes.
Okay, let me just. All right, all good. I can see it on the screen, so looks like it's all good. All right,
yes.
So. I'm a senior lecturer, as Pierre-Luc has said. I'm based at the University of Cape Town and in the Republic of South Africa. The socioeconomic context in South Africa is quite different to countries in the global north. Just a sort of quick historical background, just so that you can understand the healthcare context in South Africa. Because of years of colonization and decades of the apartheid regime, People of color were oppressed by the system, and the apartheid regime in particular developed a separate healthcare system for people of color. And this healthcare system was inferior to the healthcare system for white people. And so the new democratic government, as of 1994, had to find ways to improve the public health system, especially in areas where people of color live. And currently, South Africa has what we call a bifurcated healthcare system. And that means that there's a public healthcare sector and there's a private healthcare sector. And as in many parts of the world, the public healthcare sector is under-resourced and it services the majority of people in the country. And the private healthcare sector is really for the wealthy, services a minority in the country. And so we have this dual system, which is not necessarily based on race anymore. However, those who can access the private healthcare system, which has better resources than the public system, those people are more likely to be white people. So there are still huge divisions in wealth disparity. Rather, I should say there are still great issues of wealth disparity in the country. So my study, this is part of my PhD study, is on a practice called defensive medicine, and I have looked at it from the perspective of the rights of the child. And as I will explain, I've focused my study on the private healthcare sector. So I hope this slide changes. Yes, okay. So I'm not sure if any of you have heard of the term defensive medicine before. It would be nice to maybe just see maybe a few hands. If you have heard of defensive medicine before, maybe just if it's possible, just to send a thumbs up as a participant. If you have heard of the term before.
I think that nobody in the physical room has heard of defensive medicine. So maybe I can talk about the physical space. I'm not online, but personally, I have never heard about it. So it's very interesting.
Okay, well, if Prof hasn't heard of it, then, okay, all right. So it's not a term that's very well known, but what it means is it's a practice where a doctor overtreats a patient. So a doctor preemptively takes action to protect herself from patient complaints and from possible malpractice litigation. So the doctor takes extra steps to protect herself. So I'll give you an example of the types of defensive practices that are documented globally. It may be requesting tests that are not clinically indicated, so additional blood tests that are not required, for instance, additional X-rays or other forms of scanning, performing unnecessary interventions or procedures, arranging unnecessary or unwarranted referrals to other specialities, prescribing excessive medication. So a child might present with a blocked nose, and a simple nose spray might suffice, but the doctor will prescribe antibiotics. So excessive use of medication, hospital admissions, which might be unnecessary. It might be extended for longer periods of time than necessary. But defensive medicine can also take a form where a doctor refuses to treat certain types of patients because they are high-risk patients, where the prognosis is not very good, or they might refuse to perform high-risk procedures because of this fear of complaints or fear of litigation. So defensive medicine is, as I've said before, it is a practice that is well documented across the globe. And studies show that it is prevalent in the public and private health sectors. There have been studies done on defensive medicine, for instance, in the NHS system in the United Kingdom. There are studies done on every continent. Defensive medicine is practiced in the Scandinavian states, even where litigation is not very high. Medical malpractice litigation is not very high. It's practiced in India, it's practiced in Canada, it's practiced in the United States, etc. So it is practiced across the globe. And there are many studies on defensive medicine, but in the South African context, there's been research. Most of the research globally, I would say, on defensive medicine is in the high-risk professions, neurosurgery being one of them. But there are also many studies in obstetrics and gynecology, for instance. In South Africa, there is one academic study on defensive medicine, and it is in the field of neurosurgery. And there are indications. Before I started my research, I knew that there were indications that defensive medicine was practiced in South African pediatrics because of the rise of medical malpractice in the country. So South Africa has quite high rates of medical malpractice litigation. And there's also evidence of overservicing in the private healthcare sector. So overservicing is a practice where a doctor does more, or the healthcare system does more than is necessary. There's a European study, a review of defensive medicine, which I haven't cited here, but I can provide it if there's interest, where those scholars, Garatini and Padula, they refer to defensive medicine as a luxury tax on the wealthy. So if you are a wealthy person and you are accessing healthcare, you should expect the healthcare professional to act defensively, because the healthcare professional is aware that you have access to the legal system, you have knowledge of your rights, you are likely to complain on social media, and there are all sorts of risks to the doctor's reputation. So in my study, the empirical study that I conducted in surveying and interviewing pediatricians in the private healthcare sector in South Africa, I discovered that defensive medicine is practiced by South African pediatricians. And so you might think, well, South Africa is a country that is not a particularly wealthy country, but it is because of this, because of the division between the public and private healthcare sector, where there's still very much a wealthy minority who are able to access private healthcare. South Africa is often described as a country where you have the first world and the so-called third world in one space. So there are great disparities between the rich and the poor. And so defensive medicine, pediatricians practicing in the private healthcare sector have said that they practice defensively because they are concerned about reputational risks. They are concerned about complaints from patients. They are concerned about litigation. And in order to maintain their practice, they have engaged in this kind of medical practice, as it were. So I'm interested in the rights of the child. And so in my study, in situating defensive medicine, I needed to first understand, is it overuse? Is it underuse? What types of forms might it take? And it's clear that from the definition that I shared earlier, defensive medicine can be overuse and it can be underuse. It could be a case of doing more than is necessary, but it could also be practiced in instances where a doctor refuses to do things which are necessary. And of course, it's driven by a fear of complaints and litigation, as well as reputational concerns. In the US, this is a very famous definition of defensive medicine from the US Congress Office of Technology Assessment. This definition I found still held true in the South African context. And so just to restate that, I knew quite well going into the study that I was dealing with an under-resourced public sector and an over-resourced private sector, and I chose to look only at the private sector. So I didn't conduct a national study on all pediatricians or looking at the public and private, and that's something that still needs to that could still be done. It would be interesting to see if it is practiced in the public sector, given that studies in other parts of the world have shown that defensive medicine is practiced in the public sector. But my sense is that because the public sector in South Africa is so under-resourced, patients are not as demanding and not as, in some instances, not as knowledgeable about where to lay a complaint, how to institute litigation, etc. Whereas in the private sector, it's a different group of people who are serviced. So, of course, as a lawyer and as a child rights lawyer, I'm really interested in, is defensive medicine in the best interest of the child? And after establishing that defensive medicine is actually practiced in the private healthcare sector, I then had to consider, well, is it in the best interest of the child? There are studies which show that in some instances, defensive medicine can be a negative practice where, where more is done for a patient when it is not necessary. It can lead to negative outcomes. Conducting interventions which are not required can mean that the patient is exposed to greater risk. Hospital-acquired infections, for instance, resistance to antibiotics, where there's excessive use of antibiotics, for instance. And so I was aware that there are possibly many negative aspects to defensive medicine, in addition to it bearing a financial cost, an additional financial cost for the patient. But I was also aware of the fact that it could be the case that conducting extra tests and investigations could unearth underlying conditions, could help the diagnosis of a patient. And so I chose to look at this practice through the lens of the best interests of the child. But what does that even mean? What does the best interest of the child mean? It's a very the legal definition of the best interest of the child is quite open-ended. So for instance, of course, I had to draw on the Convention on the Rights of the Child, that's the CRC. Article 3 of the Convention on the Rights of the Child, a very important provision. I'm not sure if you have, those who are present have maybe engaged with Article 3 of the Convention. Article 3 says that let me just close this little bit so I can actually read it. In all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration. So Article 3 makes it clear that the best interests of the child provision is applicable in the public and private sector. It's applicable, the state, of course, has to regulate private actors in terms of international human rights law. But Article 3 itself doesn't tell us what the best interest of the child means. How do we define it? What is it? Is it the case that it is dependent on who decides, that it is left to the discretion of the decision maker? Is it left to the discretion of the child's parent or guardian? In the case of a doctor, is it left to the discretion of the doctor? Who decides? So Article 3 is not very clear. Fortunately, there is a general comment of the Committee on the Rights of the Child, General Comment 14, which does try to explain the various factors that need to be taken into account in determining what the best interest of the child is. And just to move on, I've also listed provisions from South African law, which domesticate Article 3 of the CRC. So Section 28(2) of our Constitution says that a child's best interests are of paramount importance in every matter concerning the child. And then the Children's Act, Section 9, says that in all matters concerning the care, protection, and well-being of a child, the standard that the child's best interest is of paramount importance must be applied. Those provisions, the Constitution and Section 9, don't explain how a decision maker must determine the child's best interests. Fortunately, Section 7 of the Children's Act provides some criteria, and the criteria that is provided is quite comprehensive. I'm not going to get into the sort of nitty-gritty of it, but there is some guidance to decision makers. And in my study, I've had to look carefully at Section 7 to see whether or not it is comprehensive enough. It does draw on the work of the Committee on the Rights of the Child, which is, of course, a good thing. Another important legal provision that is necessary to the determination of the child's best interests is the voice of the child. So we call this child participation or the child's views. Article 12 of the Convention on the Rights of the Child says that states parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. So Article 12 has been interpreted by the Committee on the Rights of the Child as being linked to Article 3, the best interests of the child principle. And the committee has said that any determination of the child's best interests must take into account the child's view on the matter. So it's very important that the child be involved in decision-making, the child be given a chance to express their view. The age of the child does not matter. The committee has said that the age of the child doesn't matter. Even very young children, even babies can express a view. It is for the decision maker to create a platform to allow this child to express a view, and whether it be through words, through drawing, through dance, children express themselves in different ways, and the view of the child is given due weight in accordance with the child's age and maturity. So it could be the case that the view of a 15-year-old who is mature would be given greater weight than the view of a 5-year-old who does not have the same level of maturity as a 15-year-old. And so the South African domestication of that principle is found in the Children's Act at Section 10, And it is a similar provision to Article 12, except it seems to place a condition on the child participating. So Section 10 says that every child that is of such an age, maturity, and stage of development as to be able to participate has the right to participate. And so, unfortunately, the way it has been interpreted is that it creates a condition, it creates 3 conditions of age, maturity, and development, and it is not as open and progressive as Article 12 of the CRC. So, in my argument, in my thesis, I argue for Section 10 to be amended so that it is in line with international law. Other provisions which are also necessary for the determination of the child's best interest and that have a bearing on defensive medicine and the healthcare context would be Article 6 of the CRC, which refers to the child's right to life, survival, and development. Article 6 is very unique. It's unique because you will not find a similar provision in the ICCPR, so the Convention on Civil and Political Rights, or in the Convention on Economic, Social, and Cultural Rights, because it is only Article 6 that refers to the survival and the development of the child. So that's fairly unique. And Article 6 takes into account the fact that a child is constantly developing. Of course, adults are also developing, and it would be wrong to say that an adult does not evolve and develop both mentally and physically and spiritually, etc. But for a child, it is far more. It can be very detrimental to a child if the child is not properly supported in early childhood, in terms of nutritional support, in terms of educational support, parental support, etc., because that can have a knock-on effect on the child's growth and development into adolescence and then eventually into adulthood. And so the child's right to life, survival, and development is quite important. And one can see how this might be fairly relevant in a defensive medicine context. If a doctor is overtreating a child, say a very young child who is taking antibiotics on a regular basis for unnecessary reasons, or it is excessive, one can see how that can lead to drug resistance as the child grows up. The child might be more prone to obtaining viruses, diseases as the child grows up, because the child has been exposed to this at a young age. So the right to life, survival, and development is fairly important. And then, of course, the right to health. We can't talk about defensive medicine without talking about the right to health. And the right to health is found in Article 24 of the CRC. And of course, the provision in the Convention on Economic, Social, and Cultural Rights dealing with the right to health is the provision on which Article 24 draws on. What's particularly interesting about this provision is that it talks about the right of the child to the enjoyment of the highest attainable standard of health. And it makes it very clear that state parties shall strive to ensure that no child is deprived of his or her right of access to such healthcare services. What's necessary, what became quite necessary for my study was reference to something called the 3AQ framework, developed by the Committee on Economic, Social, and Cultural Rights. So I've just referred to that there, General Comment 14. And the 3AQ framework refers to the 3A's, which is the acceptability, the accessibility, oh my goodness, I've forgotten the third A, and the quality of the healthcare service. And what I've really only been focusing on for my study is the acceptability and the accessibility of the healthcare service. The availability, sorry. Those are the 3A's: acceptability, availability, and accessibility, and the quality of the healthcare service. But for defensive medicine, I knew that the acceptability of the healthcare service was questionable, whether or not it is acceptable to the patient, and whether or not it is acceptable from a medical ethics perspective. I was also concerned about the accessibility of the service, particularly from an informational accessibility perspective. So has the doctor provided all the necessary information to the patient in providing the service? And then, of course, the quality of the healthcare service. There are serious questions about whether or not defensive medicine amounts to quality healthcare. Quality in terms of international human rights law, or the quality of healthcare service, is related to something called evidence-based medicine. And evidence-based medicine is really how doctors and healthcare professionals are trained. They are trained to only do what is clinically indicated, so to only do what is necessary. And of course, they are guided by their ethical principles to do the most good with the least amount of harm, etc. But quality is directly linked to evidence-based or clinically indicated medicine. So I was well aware of that defensive medicine seems to be in direct opposition to that. And then bringing it back to the South African Constitution, Section 27 of the Constitution says that everyone has the right to have access to healthcare services, including reproductive healthcare. There isn't any mention in the Constitution nor in any other legislation about the 3AQ framework. There have been judgments where there's been reference to the quality of healthcare. There's been reference to the accessibility of the healthcare. And so I was able to draw on case law to show that to some extent the state has domesticated this particular provision. So in the healthcare context, just to sum up, we have international law, and the primary provision is Article 3 of the CRC, the best interests of the child principle. And then, of course, we have the constitutional provision. And in South Africa, every provision of the Constitution in the Bill of Rights applies horizontally. And so that means that it applies vertically and horizontally. So vertically, relationships with the state and individuals, and horizontally in relationships between individuals. So that meant that doctors practicing in the private healthcare sector have to respect the child's best interests. The Committee on the Rights of the Child has also said that the best interests of the child works as a substantive right, as a rule of procedure, and as an interpretive principle. And so this means that if the best interests of the child is not part of the decision-making process, it is a procedural irregularity. So that means that the decision taken was procedurally incorrect. The decision itself needs to also, from a substantive position, it needs to also be in the child's best interests. And then I've just referred to Section 7(1) of the Children's Act that lists certain factors which decision makers need to take into account. In doing this study, I was concerned that the domestic law, and indeed even the international law, was created or drafted in such a way that it was not very clear how decision makers were to determine the child's best interests in any given matter. And I was particularly concerned with whether or not doctors would know how to determine the child's best interests. Do they just ask the child's parent, what do you think? Do they just follow what the child's parent wants to have done? If the child's parent is particularly demanding, forceful, influential, is the doctor under pressure to just comply with what the child's parent wants? Does the doctor know about the best interests of the child principle? Does the doctor know that he has a constitutional obligation to comply with this provision? And so I understood that I needed to ask doctors whether or not they were aware of this provision and how it worked. But I also needed to develop my own framework for how the child's best interests were to be taken into account. So I knew, as I said earlier, that Article 3 was important, the best interests of the child's participation was important, the child's right to life, survival, and development was important, as well as the child's right to health. But in developing a sort of matrix to determine the child's best interests, I realized that, and in drawing on the work of the Committee on the Rights of the Child, I came across something called the life course approach. And it's referred to by the Committee on the Rights of the Child, but it's also more well known because of the work of the World Health Organization. And the life course approach means that a decision maker must take into account how its healthcare decision taken today affects a person's health in the future. And of course, from a child health perspective, it's particularly important because healthcare decisions made in early childhood, even in adolescence, sets the child up for health outcomes, negative and positive health outcomes when the child reaches adulthood. And so the life course approach, I thought, was a useful tool to use in developing a sort of decision-making matrix. So ultimately, from a theoretical perspective, defensive medicine would not be in the best interest of the child when the therapeutic benefits of the practice were outweighed by the harms experienced by the child, whether it is physical, emotional, psychological, or financial. And then from a procedural perspective, if the child was not given an opportunity to participate, or if such participation or consent had not been properly informed, then the assessment of the child's best interests was not procedurally compliant. So I just want to just hone in on that a little bit. Even interventions which seem to be quite not very invasive, or interventions which are not very painful from an adult perspective, could be experienced by the child to be very psychologically and emotionally traumatic. So for instance, I'll take the example of a blood test. Most of us have had a blood test done before, and it's a very small prick on the arm usually, and we might feel some discomfort. Some of us might look away and not want to look at the needle being stuck in our arm. But more or less, I would say most people, most adults would not be physically hurt by a blood test, would not suffer in much emotional or psychological damage as a result. And so we might consider a blood test as being a type of intervention, a type of defensive practice, which exposes the patient to minimal harms. But if we look at it from the perspective of a child, the child might experience it to be a very harmful intervention. The child might be traumatized by the needle itself, might feel physical pain. The child might have emotional distress. It might create further psychological damage in the child when the child has to see the medical professional at another time. And so we have to keep in mind that sometimes defensive medicine can appear to be expose a patient to minimal harm, but when looked at from the perspective of the rights of the child, a different picture emerges. So in sum, I've got in the center of the triangle, I've got the best interests of the child. But we have to remember that there are three parties to this. It's the child. We know that the child, in terms of international law, has a right to express her view. The parent is, of course, an important party to this triadic decision-making process. The parent, in terms of international law, has, and in terms of South African domestic law, as I'm sure it is the case in Canada, the parent has significant duties to the child. One such duty is to act in the child's best interests and to make decisions to further the child's best interests. And in addition, the other party of this triangle is the doctor. And the doctor has an obligation to act in the child's best interests. And the doctor needs to be trained to know how to do that, how to determine what the child's best interests are. And of course, defensive medicine shows us that sometimes a doctor is acting for his or her own self-gain and might not be acting primarily in the child's best interests. So in my study, and there's a lot I could say, and I've tried to just hone in on a few important things. The gaps in South African law that I found is that the Children's Act does not include a consideration of a life course approach. And that's one of the recommendations that I make, that a life course approach should be included in the criteria for the determination of the child's best interest, because it would greatly help decision makers to reach decisions which are the child's best interest, and it would focus their attention on not just the immediate concerns, but the short, medium, and long-term consequences. I also found that doctors, in terms of the ethical regulatory framework, so in South Africa, doctors are regulated by the Health Professions Council, and that's every state has their own medical council. And in the South African context, I found that the ethical regulatory framework was really not child-centered. There were many gaps in the framework pertaining to the rights of the child. There was some mention of the rights of the child, but no mention of child participation, for instance. There's no consideration of a life course approach. And importantly, given the triangle that I just put up on the screen, there's no guidance given to doctors on how to manage disagreements between the parent and the doctor. And that's quite crucial for the doctor to know how to navigate instances where there's conflict with the parent, especially when the parent wants more interventions to be done than is necessary. So those are just a few of the gaps there. There are many more things I could get into, but that's just to give you a little snapshot. And so from the data, just to speak very, very briefly, I have referred to the data as I've gone along, but what the data was able to show that in the South African context, what drives defensive medicine is very similar to what is found in the global studies. So it is a concern about patient complaints, concern about litigation, and general reputational concerns. There were many doctors who were very concerned about the impact of social media on their practice, about social media that, of course, was not flattering to their practice, and about the fact that it negatively impacted their business. So they were very concerned about reputational concerns. I also discovered that some forms of defensive medicine practiced in the South African context are not in the best interest of the child. Some forms were fairly major forms of defensive medicine. Doctors said that they requested unnecessary X-rays on children and on very young children as well, exposing the child to possible harmful rays, harmful radiation. There were also doctors who said that they prescribed antibiotics when it was not needed, and it was mainly done because they were concerned about, they acted on the demands of the child's parent. The child's parent demanded medication and demanded antibiotics. So many said that they practice certain forms of defensive medicine which they knew could be harmful, and they knew was not in the best interests of the child, but they did so nonetheless. I did not interview children and parents in the study, so I only focused on the experiences of doctors, of pediatricians. So it would be interesting to look at what children and what parents think of defensive practices. Parents in particular, I think it would be interesting to know what they thought of defensive medicine, because many doctors expressed that they felt under a lot of stress, and they felt that they had to comply with what parents wanted. So they described parents to be demanding, and it would be interesting to know what parents think of that. Of course, as I said earlier, it's not known whether it's practiced in the public health sector in South Africa. So that could be further research. In South Africa at the moment, there are plans to have one healthcare system, so combining the private and public healthcare system. And there is legislation that has recently been passed to create one unified healthcare system. Whether or not this means that defensive medicine will be eliminated with one healthcare system, it's not known. And so that might also be something to look at in a few years from now, once the unified system is in operation. Yeah, and so that's the end of my talk. Thank you for listening. I hope I didn't go too fast. I was aware of the time, and I didn't think I needed that much time. But clearly I've used, I think, all my time. I would like to have questions, so I'm going to stop talking in a moment. There are a few sources that I've listed on the slide, and you are welcome to have a look at those sources. And I think this slideshow will be available on the website.
Thank you very much. So thank you, Salona, for this wonderful presentation. It was a very interesting topic, very clear the way you presented it, because it's new for me, but it was very clear, very interesting. I was not aware of defensive medicine in general, so I have plenty of questions. Obviously, I have some questions regarding the methods, how you define defensive medicine, how you sort through, what is done as a tax on the wealthy, as you said, or what is done to protect against legislation or reputational harm. I also have questions because obviously I read everything through privacy rights, and so there's a lot to say about privacy rights, and so I was hoping for having this conversation with you later on, but before I go into my questions and comments, I was wondering if there's any from the room or from participants online before I take the speech. Yes, Marita has a question.
Okay. No. Is that okay? Perfect. Do you hear me, Salona? Yes, perfect.
Yes, I can hear you.
Okay, thank you. It was very, very clear. So thank you for a French speaker. So, and I had the opportunity to hear about your work when I went to South Africa in September. And I have maybe two questions. I know that during your talk in September, you made some links between your thesis subject. I was happy to learn more today about your thesis project and the right to be forgotten. And so it was very, for me, very creative and very original to give this perspective about, to your subject. So if you can give us a few words about the connection that you made between what you talk about today and the right to be forgotten in the perspective of the right of the child. And my other question, it's not necessarily a question, but maybe a reflection. I don't know if it was in your mind during your thesis journey, but there's a lot of grayscale in health in general. Like I have a very good friend that is a doctor, and we talk a lot about the fact that medicine is probability. So sometimes a patient arrives and he will tell, okay, I have this headache and this thing in my back is hurting, or I don't know. And sometimes you make probability that, okay, it can be that, and the age of the patient and everything. And when with a newborn, it can be hard because you don't know about like the condition and is a medical history that you don't have yet. So like when you talk with the pediatrician, were they what were their justification or arguments? Were they, but we are in the best interest of the child because we don't know exactly, and we try to it's not because they want to protect themselves, but they want to protect the patient, and because it sounds like hypochondriac to say that, but with the health you never know sometimes. And it's the same, like my friend who is doctor said sometimes you are surprised, like you think it's something very minor and it happened to be something, a serious case. So yes, I thought about it, but it's not necessarily, it's more a big reflection about medicine in general.
Sure. Should I answer those questions so long, or do you want to should we take more questions? Yes. What would you like?
Oh, I think it's good because I have two, so it's great if you want to, and after that we can go with someone else. Great.
Okay, sure. So maybe I should tackle your second question first, about the reflections of the doctors. So interestingly, most of the doctors who were surveyed and interviewed, so most of the doctors in the study said that they understood defensive medicine to be a negative practice. And which was quite interesting. They understood it to be a negative practice, not strictly speaking because of the best interest of the child principle, but because of their understanding of medical ethics. And so in medical ethics, the sort of four main principles are beneficence, non-maleficence. So beneficence is to do the most good, non-maleficence is to do the least harm, autonomy, so respect for the autonomy or the rights of the patient, and justice is the fourth principle. So many of them referred to those ethical principles as a way to navigate and understand what they believed defensive medicine was, and whether they perceived it to be a negative or positive practice. But there were a few, I would say, certainly a minority, who said that in some instances, defensive medicine was a good thing because it helped to provide evidence to the parent that this is what your child has. So, for instance, a child may present to the doctor with symptoms of a viral infection, and the doctor knows on a clinical examination that this child has a virus, and perhaps it is the season, usually winter, where there are many different types of viruses which are prevalent in the community. And so the doctor doesn't know exactly which one it is, but it's probably influenza. Maybe it's, which type of influenza, the doctor can't say for sure. But the doctor, because the parent, they've said to me, well, because the parent is stressed out, is very worried about their child, wants to have medicine to take care of their child, doesn't just want to take home a nose spray or be told this virus will go away in 5 days. The parent wants to have a prescription with medication. The doctor then does a particular test. It's called a viral swab, which is like the COVID tests that we used to do, where it's a little swab is put up your nose, and on a very young child, it can be quite uncomfortable. And so the doctor will do that test, not because the doctor thinks it's necessary, but just to provide evidence to the parent that, oh, your child has this particular type of infection. But the actual treatment of the child doesn't change. So some said that to me, that they do these extra tests to have evidence for the parent. And some said that, in some instances, it can improve your practice as a doctor because you are doing more tests and you may uncover, as you said, Marie-Pierre, almost like we're not really sure what's happening, or we're not really sure, what ailment the child has. So let's just do a barrage of tests and hope for the best, and hope something comes back with an outcome that is useful. And so some said that it could also be useful in that context. So in that instance, it would be in the best interest of the child. But by and large, doctors express the view that defensive medicine is not how they were trained to do medicine. They were trained to do the least amount of harm to a patient, to use their clinical skills that they've been taught, and to be to not take interventions to be very restrained in their interventions. So to rather wait and see. If it is a virus, for instance, it usually works through the system in 3 to 5 days. rather than an infection that requires antibiotics. Those were the kinds of responses. When it comes to your first question about health data and the right to be forgotten, so that was so just to give some background, I've been also doing a bit of research on the use of health data in the large language models, LLMs, used in the healthcare sector, so these artificial intelligence type models used to assist doctors or healthcare practitioners with diagnosis, etc. And I've been considering the rights of the child, specifically the right to privacy, and in that specific context, in relation to when a child shares their, when really the child's parent shares information about the child, and the child then, may not have a say in how this information is shared, the fact that it now forms part of this data set. Can the child withdraw her personal information? And so that's when I explored something called the right to be forgotten, which Marie-Pierre referred to. And it's really the idea that can this information be deleted? Can it be removed? And of course, it's very difficult to do that when it forms part of a data set. The short answer is that it's next to impossible to be able to do that. It can be done, and there are some, but it's fairly difficult to do. And so that particular study that I've been looking at, the right to be forgotten, is not something that I've looked at in field work. So I don't know what the experiences of healthcare practitioners are. It's still very theoretical. And I hope that's enough information.
Yeah, it's great.
Okay.
Thank you.
Thank you, Salona. Yes, Antoine has a question.
I don't know where.
We hear you. I think Salona is.
Yeah, but she can't see you, so.
Oh,
Yeah.
Come here. Take my computer.
Hi. Oh, we see, even if I'm only in the front, not only in the camera. So hi, I thank you really much for your talk. You kind of put a box in my mind about the defensive medicine, and lots of observations that I've already made, like are aligned with what you said, but I didn't have the concept before. So I'm thinking about maybe scaling up at the, we'll say, national, international level with norms and policy making. I'm kind of asking myself, is those norms and like the way policy and regulation is done not part a bit of the problem? I've seen like the two examples you've given that was really sensible for me was antibiotics and also neurosurgery. In both, like in antimicrobial resistance, there are several norms now and then to reduce, and I work a lot in agriculture, and it was the same phenomena. So like all the physicians, all the sectors kind of bracking or in defensive mode because they need a massive procedural accountability. So they will do what you just said, like make more and more tests to be sure that it's official, it have been really well filed, because the sanction, the regulation is really heavy and it's kind of overloading the sector. I think it's about the same also in the health establishment, because they have the same pressure. And right now I'm asking the question, because I'm working with UNESCO on the recommendation of neurotechnology. So we talk about the neurosurgery, it's really, really sensitive. And I was kind of asking myself, am I a part of the problem or a part of the solution? Like, it is those massive and prospective and like large-scale national regulation are not scaring the medicine, the sector, and so kind of, I'm from biology, so I will say like a evolution arm race. There's kind of an arm race where the establishment, medicine establishment and political establishment are kind of rebouncing to each other, but not for the well-being of the patient, but only to be in compliance with what the other are kind of creating. So I don't know, what's your thought about that, and what's the role of those norms, all those norms, because they have a role, it's really important, I think, bottom line, but how they could proceed to not create that defensive medicine in the end.
Yeah, that's a good question. That's a good question. Thank you for explaining the context. So you know, you spoke about this tension between both sides wanting to comply, between the politics and the science, and those two sides wanting to sort of satisfy certain criteria, and in the end, it's not necessarily in the best interest of the patient. I found something similar in my study, and it's not a, you know, I would say it's tentative. It's a tentative finding, you know, so I can't say for sure because I haven't done enough work looking into it. But there were some doctors who expressed concern that they had to practice defensively because the legal system was set up in such a way that they had to defend themselves. And so the legal system and the courts did not understand how medicine is practiced. And that so for instance, in South African law, in terms of the law of torts, we call it delict for a civil claim. What is required or what is examined by the court is whether or not the doctor has acted reasonably. So the court looks at, well, what would a reasonable doctor do in the circumstances? And the doctor said to me that question asked by the courts is not in keeping with what happens on the ground. And so the courts decide what a reasonable doctor would do based on a doctor having all the information in front of him or her, and on the fact that this reasonable doctor or the reasonable standard is actually in excess of what a doctor actually does. So, for instance, they said that they are taught in medical school to do the least harm, to do the best for the patient, with the least amount of interventions. But the legal system seems to want them to do more interventions to protect themselves. If they are sued, you know, I think what I haven't looked at, what I haven't spoken about in this presentation is the impact of malpractice litigation or complaints on a doctor's livelihood. It has, you know, severe consequences, not just from a financial perspective, but from a psychological perspective as well. So the doctor is investigated, the doctor suffers a loss of reputation, and the doctor may choose to never practice medicine again. And so there were many who said that they felt that the legal system did not understand how medicine is supposed to be practiced. And so the legal system was imposing additional requirements And so they felt that they had to comply in order to survive in the system, in order to have a livelihood, and that it was very difficult to practice medicine. One doctor said to me that if he had to choose again what kind of career he would have, he'd become a lawyer, because because he said the lawyers are just out to, of course, the usual talk about how lawyers are out to make money and sue for no reason, etc. So I'm not sure if that answers part of what you're saying. I think from an international perspective, perhaps the role of these international bodies, the WHO, for instance, the Committee on Economic, Social, and Cultural Rights, perhaps their role is to ensure that states change their malpractice laws. I think that's also part of the problem. I think we need to look at, in the South African context, for instance, I think we need to consider whether or not there should be a different liability system or a different way of thinking about medical malpractice. Perhaps have specialized courts where health professionals are part of the court process in a decision-making capacity. But I think part of the problem is the blame system that the adversarial system has.
Mhm.
So the adversarial legal system is all about deciding who's at fault, and not really looking at the process, and not really looking at how healthcare is provided. And so perhaps that could be the role of these international bodies. But I'm not sure if I've answered your question.
No, it's a great answer. I like that. It echoes also all the literature on learning systems with your conclusion. And yeah, to be more grassroots, and also listening to physician, and also perhaps helping framing better learning systems with less wall of shame paradigm system. Yeah, thank you. So thank you so much.
Thank you. So I just want to jump in because I think this is very interesting. I like this idea. Well, I'm not sure I like it, but it's an interesting idea that doctors basically adopt defensive medicine to protect themselves against the law, because we normally think of the law as something that protects people themselves. So I think it's a very interesting idea because, and I'm circling back to privacy rights. As I said, I didn't know about defensive medicine before, but listening to you, it's clear to me that defensive medicine couldn't cure significant problems from a privacy standpoint. One of the clear way I can see it is that if we order more tests or you overserve the patient, more examination, then you generate even more data. And so you generate more data about the person. But from a privacy standpoint, normally, if you want to generate data about the patient, well, you have to have his or her consent. And to have a free consent or an informed consent, you really have to inform the person the reason for why you conduct this examination, why it is necessary, because
Absolutely.
As you said in your presentation, medical ethics requires that, and evidence-based medicine requires that people conduct tests when it's necessary, when it's useful, not just from a superficial standpoint. It's the same reasoning from a privacy standpoint. You can't go and get information that is not necessary or not for a legitimate purpose. And so to me, those defensive mechanisms from a privacy standpoint, they really, there's a real tension with informed consent, because basically you said it's required for a medical purposes when it's not really a medical purposes. I mean, it's really so just protect yourself. And so you have to have informed consent to act in a transparent manner. There, it's not full honesty. I mean, I'm not saying that it's complete lie. I understand the mechanism underneath it, but and then you go and take information that is not necessary and not for a legitimate purposes in terms of in terms of the law, because the legitimate purpose in terms of privacy law is to gain insight about the health of the person. It's not to protect the doctor that you run tests. And so, in my opinion, defensive medicine has really raises important red flags in terms of protecting the privacy rights of patients and even more of the children. And overall, I see also a problem in terms of trust. You said about the consequences of running those tests, even if it's the children, the long-term effect, but you can also look at the effect not in terms of the trajectory of the individual, but the social aspect of the effect also, and the way how it would erode trust towards doctors in general if people start to be aware that defensive medicine is there. And I'll just give you an example of this role of trust. I was at the doctor recently with my daughter. She's really young, and it was really a routine exam, but she has a little thing with her tummy. I mean, it's nothing. And he was like, let's just look if it's the food or something like that, like the milk. And if it's not this, we'll conduct some other tests down the road, but it's not necessary to run those tests right now. And we've had this doctor for a couple of years, and I really trust him. And it's basically what I said to my wife when I got back home. I was like, I trust him, so I think it's not necessary. But if I didn't trust him, or we were in a conflicting relationship, so there's really this trust, or he didn't trust me, we would run into those adversarial relationship where we conduct more tests, generate more information. And this is one of the things that I really see how it's a problem for privacy rights, but also trust, which is so important for privacy and confidentiality. And the last way I looked at it in terms of privacy rights is, and as you said, children do not perceive pain or reaction as adult. And there's something about privacy in terms of physical integrity also. If with a child you run a test that is not necessary, and you take blood samples or even just an X-ray where they have to go into the small little machine and put on, there's something about their physical privacy also and their integrity of the body that is taken into account. Just to sum up, because it's not a question, it's more about how we can make our two fields interact. I think it's fascinating that doctors, and I understand they have this attitude of making defensive medicine because of the nature of the legal system, that they fear it, but then to protect themselves, they have all the problems that you have identified, but also they cause really big problems in terms of privacy rights. So it was just, I think I never thought about this before, and I thought it was very interesting. So one of the questions that I had for you is, in your interview, did the privacy rights and the way that we generate just more data, and afterwards you have to secure those data, they could be used for research and secondary purposes. And so was the question about generating more data and the impact on privacy was raised by the medical professionals?
So in terms of the right to privacy, there were, doctors approached it not from a right perspective. They spoke about autonomy, and from an autonomy perspective, so that's how they framed it. They said things like, there were very few actually who referred to the child's autonomy or the child's privacy, or there were very few doctors who referred to that. But the vast majority spoke about the parents' autonomy, or respecting the parents' wishes for the child. But there were very few who considered the child's autonomy, let alone the child's privacy. In terms of my study, the way I've framed it. Of course, the informed consent, the child's right to participate is an important part of the determination of the child's best interests. And so the child's right to participate includes general participation as well as informed consent. And in both instances, the child needs to be provided with all information. So all relevant information in order to express a view in the first instance, and to consent in the second instance. And of course, the informed consent is for older children. It's usually determined by legislation, the age of the child. And in South Africa, it's a child who is 12 years and older, and has the requisite maturity, etc. So I was concerned about the kind of information, the quality of the information shared. Most doctors were concerned primarily with the views of the parent. They were not concerned about the views of the child, the rights of the child in that instance. So from a child rights perspective, that showed me that they were concerned. They viewed the child more as being an extension of the parent rather than being, her own person. And so and that's a very traditional, old-fashioned way of thinking about children as being extension of their parents. It doesn't take into account the fact that children have rights, have agency, etc. And so that was quite concerning. So I didn't frame it as a privacy aspect in particular, but I certainly looked at aspects of bodily autonomy, because that's very much protected in the South African Constitution, the right to bodily autonomy and integrity, which forms part of the right to privacy. Yeah.
It's very interesting. It's very interesting because, we're always looking out for new ways to think about privacies and where, issues from a privacy standpoint or threats for privacy may arise. And I never thought about this. So thank you very much for this. It was very interesting. I have one last question, more a methodological question. When you try to sort through what is considered as defensive medicine or not, and how you define it, especially in the private sector. Because, as you said, I don't know, it was a report or somebody said that it was defensive medicine is also like a luxury tax on the wealthy, health tax on the wealthy. So how can you, when you overserve a patient, how can you distinguish between it's defensive medicine that the doctor is trying to protect his or himself from responsibility or litigation or reputational harm, and with it's just a tendency, especially in the private sector, to overservice to generate more revenue. How can we distinguish between those two? And if it's just to generate more revenue, is it still called defensive medicine, or it could be called capitalist medicine? Because it's not to defend yourself, it's to defend your wallet, maybe. But so how do we distinguish between those two? Because it must be hard, probably, that it wouldn't be that open to say, well, we're just overcharging to make more money, and so it's just to protect ourselves. Sounds more like, we don't have the choice because the legal system doesn't understand us. So how can we sort through what is a real claim, what not claim? It must be very hard from a method point of view, but I was just wondering if there's something there that you were, what angle were you working through with this problem in your research?
Yeah, that's part of the difficulty. That was most certainly part of the difficulty. I, initially thought, should I examine the actual practices of, look through maybe hospital records, and try to ascertain, of course, now that's going to incur privacy issues as well. How do I determine whether or not a child being admitted into hospital for 5 days is a defensive practice? How can I objectively determine that? And so the studies that I referred to, in my study on defensive medicine, the studies done in other parts of the world, have all have asked doctors whether they practice defensively. This is what defensive medicine is. This is a general definition of defensive medicine. Have you practiced defensively? What are the forms that you have practiced? What are your motivations, etc.? So, that's part of the limitation of the study, that I'm really restricted by the subjective responses of doctors, because it's quite difficult to examine this any other way. Without having access to all a range of information on the medical condition, and of course that's going to be very difficult to get because of issues of privacy, etc. So I had to rely on the views of doctors, and part of that is that I was also concerned that some of them may use the study and my questions as a way to platform their own interests about, we are unhappy with the legal system, we are unhappy with the medical council, etc., etc. So to sort of platform their own interests in the process. But there were some who said that, of course, there's a parallel financial gain, and that we have to be aware of that. There were also some who said things like, this is how private healthcare works. It's apart from the litigation system being the way it is, private healthcare is a very competitive space, and you need to retain your business. You need to have a livelihood, so you have to do what you have to do. It's necessary in order to survive. So part of my finding is that we have to accept that the reasons are likely to be mixed, and that because for that very reason, that it's very difficult to extrapolate one particular driver. It's probably a combination of different factors.
Yeah, it's very interesting, very interesting. The challenges that you identify are also challenges that we have in qualitative research in general. How we sort through what is said, but what is latent in the data also. Anyways, it's 1 o'clock here. We've run through 5 minutes, extra 5 minutes. But thank you very much for this presentation. It was really, really interesting, and the way you present things is so clear. It's very, very it gets your mind going. So thank you very much for the presentation, Salona, and I hope that we'll have the chance to speak soon about how the intersection between defensive medicine and privacy rights, because I think there's something there to be done. And so I think we can do a final round of applause for her. Thank you very much, Salona.
Thank you very much.
What time it is in South Africa, but it's 8 o'clock probably.
Yeah. It's dinner time.
It's dinner time.
It's dinner time.
Bon appétit.
Bon appétit, we say in French. Have a good meal.
Thank you, and thank you both for this opportunity. It's wonderful to make this connection and to have this collaboration. So I really appreciate it, and thank you very much, Marie-Pierre, for all the work that you've put into getting this off the ground. So thank you. Yeah.
Absolutely. Thank you, Marie-Pierre. And thank you, everybody online. So our next seminar is, I don't have my notes.
On March 4th.
On March 4th, when we're still be on the topic of the children's rights and privacy rights. And so I'll see you in March 4th. So thank you very much, everybody. Have a good meal, have a good night, Salona, and I'll see you next time. Thank you very much.